Hello, my name is Robert Cost, and I'm the principal attorney with General Counsel Online, an online on-demand legal service offering subscription-based fixed-price affordability. General Counsel Online produces Lawgorithms, which simplify business decision-making about legal matters. Lawgorithms are designed to help the business person think clearly and logically about everyday legal issues, and by so doing, make better business decisions. This logarithm is designed to help you understand what a Pennsylvania business must do if it is the subject of a data breach. Now, every state in the country now has a law requiring businesses in that state to report a breach of data stored in their computer systems. Although similar, these laws often vary in detail, so we'll focus on the 2006 Pennsylvania Breach of Personal Information Act, which we'll simply call the Act. This logarithm will walk through the steps involved in determining whether and how a business must notify others of a breach under the Act. Now, please beware that your business may be governed by other laws related to reporting data breaches, and you should consult with your attorney anytime you have a data breach. We may explore these other cyber security issues in future logarithms, but for now we're narrowly concerned with the Act, which is plenty for one presentation. First, here are the steps involved in complying with the Act. At its simplest, the Act says that any entity that has a database of personal information that has been breached has an obligation to notify the individuals whose data was compromised. In order to understand whether this applies to your business, your data, or your data breach, we need to unpack a few things. First, the Act governs all entities that maintain, store, or manage computerized data that includes personal information. The entity can be a governmental agency, a political subdivision, such as a town or county, a business doing business in Pennsylvania, or even a natural person who's a resident of Pennsylvania. So, given that you're likely an entity, there remain three criteria determining whether you're covered by the Act. First, do you maintain, store, or manage data? Though not defined, the plain meaning of this phrase is broad enough to cover just about any computer-based writing or reading of data, whether the system is local or cloud-based. It even covers companies whose business it is to destroy documents. Second, are the data computerized? The Act does not cover paper records that might be broken into or stolen, and whether it covers digital records stored on, say, disk is not clear. Perhaps they only become computerized when attached to a computer. Lastly, do the data include personal information? Because only personal information is protected by the Act, and it has a very specific definition. Personal information is a first name or initial and a last name in combination with or linked to an unencrypted or unredacted Social Security number, driver's license number, or credit or debit card number together with an access code. This definition of personal information is actually quite narrow. It does not include business, medical, financial, legal, family, location, or other information we might ordinarily think of as private or confidential. An individual's name can be either in combination with or linked to one of the three protected types of information. This includes not only information resident in a single database, but information linked to the name by means of a foreign key in a database or a URL to an endpoint containing the information. Lastly, the linked to data must be unencrypted or unredacted to be personal information. If the information is protected by a, quote, algorithmic process which, quote, creates a low probability of assigning meaning without the use of a confidential process or key, it is not personal information, and therefore there's no reporting requirement under the Act. The conclusion here is that even if you have a website, an email account, a database, or a business application that has been hacked or breached, you're not subject to the Act if you're not dealing in personal information. But the analysis doesn't end there. Once you've detected a breach or an intrusion, you'll need to consult with your attorney to see whether your business nevertheless has reporting or other obligations. You might have reporting requirements under federal law, such as the Healthcare Insurance Portability and Accountability Act, or HIPAA, or the High Tech Act related to medical records, or the Gramm-Leach-Bliley Act. You may be also bound by rules made by the Federal Reserve, the FDIC, the Federal Trade Commission, or other federal agency rules. And depending on whose data was compromised, you may also have obligations under the European General Data Protection Regulation, or GDPR, or under the California Consumer Privacy Act, or CCPA. And lastly, you may have contractual notice obligations pursuant to confidentiality and trade secrets protection agreements you may have signed. If your personal information has been compromised, the next question is whether a breach has occurred. The Act defines a breach as the, quote, unauthorized access and acquisition of computerized data that materially compromises the security or confidentiality of personal information maintained by the entity as part of a database of personal information regarding multiple individuals, and that causes, or the entity reasonably believes has caused or will cause, loss or injury to any resident of this Commonwealth. This run-on sentence has 5 conjunctions in it that serve to further limit the scope of the Act. First, the personal information must have been accessed and acquired without authorization. If it is merely accessed and not acquired, say viewed rather than downloaded, the Act is not invoked. An intrusion without acquisition is not a breach as defined by the Act, and therefore not subject to its reporting requirements. Now, requirements number 2 and 4, that the data compromised must be, quote, material, and that it be reasonably believed to cause loss or injury, are both heavily fact-based injuries and something to be explored with a lawyer with whom you're working on this incident. Requirement number 3, that the compromised personal information be maintained as part of a database of multiple individuals' personal information, further limits the scope of the Act. Compromise of a single record, say a single email or a text file, which contains or is linked to the personal information of an individual, would presumably not be a breach, subject to notification requirements. Lastly, in Requirement 5, we understand that it is only the personal information of Pennsylvania residents that the Act's interested in. A resident of PA is any individual whose principal mailing address, based on the computerized data itself, is in the Commonwealth of Pennsylvania. Now, even though the Act ultimately defines breach in a fairly narrow way, the business that is subject to the cyber attack should not assume that its notification obligations end there. For example, the GDPR defines breaches broadly to include data destruction, loss, alteration, disclosure, or even access. If you're collecting data on European citizens or even citizens of other states within the United States, you'll want to think more broadly about what constitutes a breach of a data system. Now, the Act carves out 2 exemptions from strict compliance. The first provides that if a firm maintains its own security and notification policy, quote, consistent with the requirements of the Act, it may follow its own policies. I, for one, do not believe it would be safe for a firm to conclude that it is in compliance with the Act based on its own self-assessment. Second, the Act also provides for safe harbors if a firm complies with certain federal agency rules concerning breach notification, details we're not going to explore here. If your cybersecurity incident fulfills all of the requirements of the Act so far, you must provide notification of the breach, and must do so without unreasonable delay, taking into account any measures necessary to determine the scope of the breach and to restore the reasonable integrity of the data system. Notice may also be delayed if, quote, a law enforcement agency determines and advises the entity in writing, specifically referencing this section, that is the Act, that the notification will impede a civil or criminal investigation. Whether this means that the business has a duty to first inform law enforcement of the breach is not clear, and the Act imposes no such duty. But a conservative attorney might have the business pass the breach by at least local or state law enforcement before making its notifications. Now, if the cost of notifying the individuals whose records were breached will exceed $150,000, or if the number of records exceeds $175,000, or if the entity has insufficient contact information for the individuals to notify them in writing, by phone, or via email, the entity may provide substitute notice. Such substitute notice would be an email notice together with a conspicuous posting of the notice on the entity's website and notification to statewide media. If substitute notice is not warranted, you must notify each Pennsylvania resident whose data was accessed and acquired. The notice can be made by email, phone, or a written letter to the individual's Pennsylvania address. If notification is made to 1,000 individuals or more at one time, notice must also be sent to all consumer reporting agencies such as Equifax, TransUnion, and Experian. With notices having been sent, your business's obligations under the Pennsylvania Breach of Personal Information Act are now fulfilled. Responding promptly and proactively to a data breach requires that the business have a technical and legal playbook or procedures manual for the inevitable data breach. It's important that your business not use its first breach to scramble its response to the technical and legal matters. Just as it might prepare for a fire, your business should document and even practice a response to a cybersecurity intrusion. General Counsel Online helps its clients assemble just such a playbook, addressing the specific legal response appropriate to the client and its business and its data. Now, I hope this logarithm is useful to you in thinking about data breaches and your business obligations to notify others. Please feel free to read or download a copy of it at the above web address. As always, this logarithm should not be construed as legal advice. Consult with your attorney before taking action on a data breach. Everything turns on the specifics of your business, your mark, and your situation. If you're a Pennsylvania company, we welcome your inquiries at General Counsel Online. Thank you for your time and attention, and best of luck to you.